Wow, today in court with Vince Davis was mind-blowing. I can't even put into words. I wish he could be videotaped so you could see this genius man.
Good morning. Today's title, Special Evidentiary Issues in CPS Hearings, How to Win or Lose a Case Based on Evidence Alone. Welcome to CPS Office Hours. I'm Attorney Vince Davis. In today's live stream, we are covering a subject that is rarely understood, but controls everything in your CPS case, and that is evidence. You don't lose CPS cases because you're a bad parent. Many times you lose cases because you didn't know how to challenge the evidence or how to get your evidence into the court. Or worse, you didn't even know you could. Today we walk through the special evidentiary issues that come up in CPS hearings. What's allowed, what's not allowed, and how to protect your rights from the very first hearing to the appeal. So let's begin. Part 1, the foundations of evidence in the juvenile court. The juvenile court does not follow strict evidentiary rules like a criminal court or a civil court. A lot of people find that hard to understand or hard to believe. Relaxed standards under Welfare and Institutions Code Section 355. For example, hearsay is allowed in certain social worker reports. Hearsay and multiple hearsay. Social workers' reports carry weight unless you object properly. You know, I explained something to Ms. G last week. By law, the social worker's report has to be let into evidence and considered by the judge. The best thing you can do is refute it or discredit it. One of the key points, you can challenge the accuracy of the report, the basis and the hearsay in the reports, but you must preserve all of your objections on the record. Part 2. Hearsay in CPS cases. CPS reports often include hearsay, double hearsay. For example, the child told the social worker who told another social worker who put it in the social worker's report. It includes anonymous tips, which is hearsay. It includes school or therapist statements, which is hearsay. In a criminal case and in most civil cases, this would never be allowed into evidence. But in CPS cases, it is allowed. And the Supreme Court, at least of California, has found that this is constitutional. So you and your attorney have to come up with a strategy. You have to request, and you have this right, for the declarant of the hearsay statement be brought into court to be cross-examined by you and your attorney. You can demand an evidentiary hearing and cross-examine the reporting party if at all possible. Here's a tip. Hearsay is admissible under the Welfare and Institutions Code, but not if it's the sole basis for jurisdiction and you can object. Part 3. Police reports, hospital records, and mandated reports. Police reports may include statements that would never be allowed in criminal court. Medical records may contain speculation by doctors. Mandated reporter calls are confidential, but the content can be challenged. And by mandated reporters, I mean like school teachers, like therapists. So here's the strategy that I often employ. I subpoena the police officers, the doctors, the school staff, the teachers. I bring them into court to be cross-examined about the reports that they have made to CPS. Sometimes I file a motion to exclude evidence that is unfounded or just their opinions that is not supported by any fact. Those are called motions in limine. Talk to your attorney about filing such motions. Consider using expert testimony to discredit these unsupported claims. Part 4. Social worker reports the judge's primary evidence. Listen, by law, the social worker's report comes into evidence, and the judge must consider it. So basically, these reports are treated as gospel by many courts. They include timelines, summaries, and conclusions. The problem with these reports is they often are biased summaries. They are missing context, and things are taken out of context. And a lot of times they omit favorable evidence for the parent. The solution: submit or consider submitting a rebuttal declaration. A lot of lawyers don't like to do that, but in some cases it may be helpful. To that declaration, you can attach exhibits, logs, certificates, letters. Instead of a declaration, you may want to do a trial brief or have your attorney do a trial brief. And another solution is ask for a contested hearing to challenge the report and its contents. Part 5. Drug tests and evidentiary pitfalls. CPS uses drug tests aggressively, but positive screens without confirmation testing is not proof of a dirty drug test. This comes up so many times. A drug screen, in my opinion, does not meet the Kelly-Frye standard for admitting scientific evidence of a positive drug test. A drug test is different than a drug screen. So on these drug screens and drug tests, make sure that you and your attorney challenge the chain of custody, challenge false positives, challenge prescriptions that may conflict with your tests. Some of the strategies that you might consider: we always request a retest. That's required under federal law. You might want to consider a blood test or a hair follicle exam. You want to submit your prescription evidence. And you may want to cross-examine a test provider. You may even want to hire an expert to go and view the testing facility. About a year ago, I was talking to an expert who testified in a criminal case that when he went to the facility to see the procedures they put through for testing methamphetamine, that the facility did not have the final, testing equipment that is needed to test for illegal methamphetamine. And he told me that most testing labs don't have this final piece of equipment because it was so expensive. And he said, and without that final testing machine, the test for positive methamphetamine was not admissible because it didn't meet the Kelly-Frye standard. And he told me you wouldn't know that unless you had an expert go into the lab and look at the process and make sure that they had that final machine or testing equipment at the very end. Something that I didn't know. Part 6, expert witnesses, your evidence superpower. CPS often brings no experts, just reports, just the social worker's opinions. And by the way, most social workers, maybe 99% of them, they're not experts. They're not doctors. They're not psychologists. They can't legally, in my opinion, give a diagnosis. You can bring in experts. Here are some of the experts that you might want to consider: a DV specialist, a drug addiction specialist, drug counseling specialist, a parenting therapist, psychologist, toxicologist for those drug-related allegations. File your expert witness list in advance so that the social worker's attorney or the minor's attorney can't claim surprise. Submit the summary of their testimony. A lot of experts, you might want to have them do an expert report. Okay? Not required, but a lot of judges and prosecuting attorneys would appreciate that. Your expert testimony becomes a lot more persuasive when you submit their report and their resume before they testify. Part 7, video, photos, and digital evidence. Everybody has a camera and a video recorder nowadays. It's in your phone. Phone footage of visits, photos of home, food, and cleanliness. Text messages with caseworkers. You can buy an app for, I think, less than $10 where you can now download text threads between you and any individual, such as the social worker. Rules. These documents, photographs, videos must be authenticated. Talk to your attorney on how to authenticate a document. They must be relevant, and they cannot be overly edited or manipulated. So the strategy you should employ is include photographs with your declarations and your exhibits. Use timestamps and dates to support your timeline. Part 8, filing motions on evidence. Consider with your attorney motions to strike hearsay, motions in limine to exclude prejudicial evidence, and a motion to compel release of CPS files or video footage. You want to make sure you're using the Welfare and Institutions Code as a legal basis. You want to make sure you use California Code of Civil Procedure, Section 1985. It's a notice. It's a subpoena pursuant to notice. And take a look and review California Rules of Court 5.690, Part 9, Evidence on Appeal. The question becomes, did the judge rely on improper evidence? Were objections made by your attorney on the record, which you can appeal from? You want to make sure that you and your attorney preserve your record on appeal. You want to file maybe written objections. You want to make sure you have that evidentiary hearing where you cross-examine the social worker's witnesses, including the social worker. You want to make clear what was allowed over your objections. Appeal the judge for abuse of discretion for relying on improper evidence, such as hearsay, multiple hearsay, or your denial of due process. Closing. Evidence is how you win or lose a CPS case. They'll say it's just a report, but in court, that report is your case. If you don't know how to challenge it, it becomes the truth. And if you do challenge it, you can win. Give me a call. Let's evaluate the evidence in your case. If you have any questions this morning, drop them in the chat, and I'll be happy to answer them. Remember, you want to fight your CPS case smart with evidence. All right. See if there are any questions this morning. All right, from YouTube, Cruel Dotrick says, good morning, Attorney Davis. Dorothy from Facebook, good morning. Dorothy's from North Carolina. Margaret, who's a member of our YouTube channel. Good morning, Margaret. Okay, I see no questions this morning. So we'll see everyone tomorrow on my office hours, 6:30 a.m. Pacific time. Everyone have a good day.
With this amazing God-given brain and talent, he outsmarted everybody, and he's still going, and I am so excited and I have so much faith and peace that we are going to win. It's coming.